Hey everyone, my name is Tim. You're watching Lost in Law. Today, we're going to be talking about consent and the limits thereof. We'll be looking at the Jobidon case, a case out of the Supreme Court of Canada in 1991. Now, you might be asking, the limits of consent? What are we talking about here? Is this some sort of, you know, adult activity type thing? Well, no, as we're about to find out, consent actually applies to a lot of facets of law. So, let's have a quick look at this. Now, the Jobidon case is huge. We learn it in first year law and criminal in criminal law because the accused was charged with a crime and had a pretty interesting defense to it, which went all the way up to the Supreme Court. All right. The first thing you're going to recognize is what is this R that we're talking about? When we talk about Canadian law, the R just stands for Rex or Regina, which is Latin for king and queen. In Canada, all crimes are against the crown. That's unlike the US, where the crimes are against the people. Hence, the people versus the accused. Here, it's just R v. the accused. SCC there, Supreme Court of Canada. We'll have a look. This case comes out of Ontario. These are the judges present. Does not matter. This section here is an editorial added by the Canley staff. So it is nice for kind of quickly framing the issue. It's not actually part of the decision. And of course, they have the criminal code cited. So in Canada, the criminal code is federal jurisdiction. A crime in one province is a crime in every province. So, it's helpful. However, the application of the code varies province to province. So a decision in Ontario is not necessarily binding on a decision in Saskatchewan. However, the Supreme Court of Canada, so it's binding on all provinces. Now, we're going to quickly look at the set of facts, and then I'll go through some of the items here and what they mean. So, the accused was charged with manslaughter through the offense of assault following a fistfight. The fight started in a bar, and then it spilled outside. There was a break in the fight, but then it spilled outside, and the accused and the victim squared up, had a fight. The victim died as a result of the punch that he sustained from the accused, or the convicted in this case. So at trial, the accused was found not guilty. The victim had consented to a fair fight. All right. Goes to the Court of Appeal of Ontario, and they set aside the acquittal and substitute a guilty verdict. Of course, Jobidon appeals to the Supreme Court, saying that what the Court of Appeal did was incorrect. So we are looking at the issue of consent in a consensual fistfight. Does that absolve the accused of all of the consequences of that fight? Now, this right here, right, assault under Section 265 of the Criminal Code. We'll have a look at that in a second. But those are the basic facts of the case. Of course, the spoiler alert. The decision was that the appeal should be dismissed. Therefore, the manslaughter conviction is held up. So Jobidon is guilty of manslaughter, and he's in jail. I don't know if he's still in jail. I'll have to look up if he's still in jail, still serving that sentence, but that's immaterial to this discussion. What we're really looking at is the limits of consent. Can you consent to a fist fight in which you die in? So let's define the terms first. In Canada, manslaughter is a culpable homicide. So that's covered. Section 221 of the Canadian Criminal Code, right? A person commits a homicide when directly or indirectly by any means he causes the death of a human being. All right. The culpable homicide is a murder or manslaughter or infanticide. It's not a murder, it's not an infanticide. We'll just go ahead and just leave those aside. We'll only cover the stuff that's involved with manslaughter. Perfect. You have committed a culpable homicide when you, by means of an unlawful act or by means of criminal negligence, caused the death of a human being. So, criminal negligence was one of the issues raised. It was the secondary issue. Part of the facts of the case is that the guy got knocked out and the accused kept punching for a few seconds afterwards. And because the victim is knocked out, were you negligent in continuing the fight? The court did not buy that argument. It's really easy to dispose of it. Criminal negligence is a either by act or by omission when you had a duty to act. That something bad happens. You show the disregard for human safety. That's what criminal negligence is, right? The reckless or wanton disregard for human safety. If you are intentionally in the fight, though, and you know that fights are unsafe, then it's not a disregard of that. So that's why the criminal negligence test failed. If we go back to the down here later in the in the decision, right? A fist fight hits the term assault perfectly. Criminal negligence is less tailored for this situation. There's the obvious intention to apply force, this conscious regard for some level of harmful consequence distinguishes assault from criminal negligence, right? So what the court has done is they said, okay, this argument's not going to work. So we're going to focus on this argument. By means of an unlawful act, you've caused the death of a human being. The unlawful act is the assault. So we're going to go down to section 265, and look at what an assault is. Then, well, now we know why the trial judge found not guilty. The letter of the law says, without consent, you have applied force, intentional force, directly or indirectly to a person. So if we go back up to manslaughter, to section 222, there we go. The criminal code is long and it's all one document. I don't know why. Anyways, so back up to 222 for homicide, right? You've committed the culpable homicide by means of an unlawful act. So you have to prove another crime occurred. That crime, of course, is assault. We get down to what is a manslaughter. A manslaughter is just not a murder. That's it. If you're not right, these are all the different ways that you can get to murder. And then, of course, there's infanticide, which clearly does not apply here. So if you have a culpable homicide and none of those other things above covered it, then it's a manslaughter. So that's a really easy test. We know we're at manslaughter because a person is dead and it was your fault. We're just trying to figure out exactly which of these words will make it your fault. So, anyways, back down to 265. There we go. Now, you did see there is this little thing here about consent. So these are the exemptions of consent, which they say that you cannot consent. You cannot force someone to consent through the application of force or the threat of the application of force. Now, you might say, well, okay, so is a fight not the threat of an application of force? However, you're not obtaining the consent by the threat of, hey, if you leave this fight, I'm going to make you fight anyways. Right? This is just squaring up. Not much was said, and certainly not in the fact pattern. Not much was said between the two individuals. You're squaring up. The other person squares up. That's not a threat or a fear that is forcing the consent. So this was not even addressed by the Supreme Court of Canada. The facts just don't fit it. But yes, of course, you can't use force to obtain the consent and then say, well, it had the consent. So yeah, that's not going to work. Anyways, so that's the issue we're dealing with, right? This part right here, if you just read the letter of the law, says, well, this guy's not guilty. He had the consent for the fight. But of course, you can't consent to certain things, right? We all recognize, and some people might be dismissive and say, well, I should be able to consent to someone shooting me in the head. But that's not how the law sees it. That's not how we've typically seen it. And so, of course, the trial judge is only bound by the letter of the law. They can't just invent a reason that this applies or doesn't apply. He read the law, he applied it correctly. Of course, it goes to the Court of Appeal and they say, okay, yeah, you read it correctly, but there's this thing you didn't consider, and so we're going to make the guy guilty. The Supreme Court says, okay, clearly we have this, issue that needs to be addressed. So we're going to establish the jurisprudence on this. So they do so with this sentence right here, right? Limits on consent to assault have long been recognized by English and Canadian courts. There are things you cannot consent to. Okay, so what are those things? The easy one is a murder, right? You can't consent to be murdered. The person is still going to get convicted of a murder. Now, does that apply to a fist fight? The relevant common law policy. So, there's a lot of stuff here that the court's going to go through where they're just kind of setting up, the justification. If you want to go look at it yourself, you can look up R.V. Jobidon, 1991, Supreme Court of Canada. You can go look it up yourself, but I'm just going to pick out some of the important parts here. And the idea that there are limits and the code doesn't dispose of those limits. There is a general say, okay, you don't have consent, but that's more of a general statement saying that, well, if someone says high five me and you hit them and slap their hand and you have caused you've caused a trivial amount of pain. It was a pretty hard slap, but you didn't cause any severe injury of any kind. It was just a hard slap. That will not, you can consent to that. What the court really wanted to establish was that there is limits to the injury that you can suffer. Yeah, right here. The limitation demanded by Section 265 vitiates consent between adults intentionally to apply force causing serious hurt or non-trivial bodily harm to each other in the course of a fight or a brawl, right? So these are the important parts. You can consent to force that doesn't cause hurt or force that causes trivial bodily harm, like a paper cut or, Indian burns, wedgies, all the typical stuff that you see in playground behavior, right? Even just play wrestling, which is technically an assault. Certainly, if you didn't have permission and you come up and do a suplex on someone, that is an assault. But if you do have consent, you're like, hey, we're, especially as kids, right? Go ahead and suplex me on this mat or this mattress. Yeah, you're not committing an assault. You have the consent and it's reasonable. However, you start consenting to things that have serious injuries or non-trivial bodily harm, and we're starting to get into the limit of the common law issue of consent. So, there's some justification here that is pretty complex legal stuff, and as a first-year law student, I don't quite understand all of it. But what I will say is it's kind of setting up here for a statement that the intent of Parliament in outlawing assault is we didn't want people going around punching each other. It also holds that, well, we don't want people going around and punching each other, but we're not going to make an exception for people who want to punch each other. Like, we also don't want that behavior. And when I say we, look, it's the societal objective. So whether you agree or disagree with it, that's your prerogative as a judge. But you're not a judge. You don't get to do these you don't get to say, well, it's my standard. Well, no, it's the legal standard. Of course, that goes into subjective versus objective, and that's something we'll cover in a different video, but there are things that it does matter what you were thinking at the time. This is not one of them. Yeah. These two judges here, they had wouldn't say it was a dissenting opinion because they still said the guy was guilty. They just used a different route to get there. So they actually used the criminal negligence by continuing to punch the guy after he was unconscious, right? The accused, by continuing to pummel the victim after he knew the victim was unconscious, knowingly acted beyond the victim's consent. So they're just sorry, no, not the negligence. No, they're back on the assault, but they're saying that the consent was withdrawn as soon as he'd lost consciousness. Given a finding that the accused committed an assault and given the victim died as a result of that assault, the accused is guilty of manslaughter. So, and that was the result of the case, right? So the appeal was dismissed, the manslaughter conviction was upheld. These two judges went a different route. They just said that the consent ended once the guy fell unconscious and you continued to pummel him. The problem, though, is that the medical evidence doesn't say exactly which punch was fatal. And you have to prove beyond a reasonable doubt, and reasonable doubt exists if there are 6 punches and you can't prove which one was fatal, and you're using the last punch to prove that the assault had occurred. Right? So again, we're back. So without, let's pretend that this stuff we just talked about didn't exist, right? The whole idea that there is a limit to consent. Let's assume there is no limit to consent. You can consent to anything you want up to and including murder. Cool. That consent is withdrawn as soon as you lose consciousness. We're also cool with that. Here's the problem. Which punch caused the death? Remember, that word cause is very... The medical evidence wasn't good enough to say, well, it was the first punch. No, it was the 6th punch. We don't know. So now you have reasonable doubt. You would find not guilty because of reasonable doubt. We're not sure if the punch that you had consent to led to the death or the punch you didn't have consent to led to the death. So this, again, you're splitting hairs here, but this was not as clean a way to deal with this case. Now, what they did by putting the limits to consent was also not a clean way because it's actually going against the clear wording of the text. What the Supreme Court has done is said, well, yeah, Parliament wrote it down this way, but what they were actually intending was something else. And that's where that's why lawyers get paid a lot of money to understand this kind of stuff. They make these kind of arguments, and the court has to, they have to fight through all this stuff. But this is what was decided, and now it's jurisprudence here in Canada. There are limits to consent in the context of assault. You cannot consent to an assault that causes serious hurt or non-trivial bodily harm. So it's not your defense to say, well, the guy asked for it. The guy squared up and fought me fairly, and then he died. Of course, now you're saying, well, what about UFC or street fighting? Well, the court says there's no social value in fistfights or street brawls. You may disagree with that, but that's the court's finding. That's the court's reasoning. There's no social value in fistfights or street brawls. There is a social value in mixed martial arts sports or boxing. They're entertainment, they're art, they're forms of art. That's been law for a very long time, right? Entertainment is a form of art, and artistic expression has social value. Again, you may disagree with that. That's not the law. Of course, the reason that there's no social value is that those activities may even lead to serious breaches of the public peace, right? You get a whole brawl. People start pulling knives or guns or other weapons, right? A lot of bad things happen when fist fights and unsanctioned street brawls break out. So we were able to use this decision that there are limits. There's limits. Look, if you're engaged in an activity that has no social value, you can't consent to it and then immediately release yourself of all guilt of the consequences. So there you go. That is the limits of consent under the Jobidon decision. Hey, I hope you guys found that interesting. Next week, I do want to look at some other aspects of what is a manslaughter, what is a murder. We actually are going to look at the Sammy Yadam murder trial. That was Officer Forcillo who had shot a person holding a knife on a Toronto above ground transit car. It's like a what is it? A streetcar, right? It's an above ground streetcar, and a guy under a serious mental health breakdown started walking around with a knife. Police were called. The police engaged the suspect, shot him, and a lot of other things happened. So we'll be looking at that case. There was video of that case too, and I think it's important to look at the video before we talk about the case. So look forward to that next time. Hey, I hope you guys enjoyed this. If you want to see more of this content, or if you have questions that I can address, again, this is in the context of a Canadian law student. So I will display this now. I am not a lawyer. It is not legal advice. Contact a lawyer in your jurisdiction for advice. And I may get things wrong. I may get learning still. I have no trial experience. I am just learning how to be a lawyer. And so I may get things wrong. When I do a midterm and final exams, I may make mistakes of the law on them. And so if I have, be sure to point it out. Until next time, stay frosty.